right, good morning. It is February 20th. We're taking up S45 and we have Steve Collier, General Counsel from the Agency of Ag, just to provide the agency's perspective.
Great. Well, good morning, everyone. Thank you so much for having us. I'm actually pretty excited to talk about this bill, and I don't get excited all that often. So we do really appreciate the opportunity, and we're really encouraged that 22 senators sponsored it too. That's kind of a welcome development. So since I'm assuming you don't spend a lot of time on agriculture in this committee, I thought it might be helpful to just give a little bit of background about why we think this matters. And I think to do that, I don't know if any of you want the existing law, but it fits on one piece of paper. And I think it's helpful to look at it front to back.
And also just for time keeping sake, it's about 15 to 20 minutes. All right. Because I know we have a few folks on Zoom as well. Does that work?
I could take probably more, but I'll take whatever you give me and I can always come back.
Okay.
That works as well.
Can I ask a question?
Sure.
Is there a way that they could actually dial in now because they're waiting and I don't have an opportunity I don't have the phone numbers and I don't want them to just leave.
Yeah, I think.
And I think they'd want to probably hear what the agency has to say.
Yeah, I think if our committee assistant has sent them over the Zoom links.
Does it click on? Okay, thank you. I just want.
Yeah, they can.
That's perfect. Just changing the schedule. I want to make sure everybody was connected.
Got it.
Thanks.
Thanks.
Okay. So I think a great place to start is why this bill matters is to look at what the legislature said about it. And so in section 5751, the findings and purpose, that initial paragraph, the legislature, I think, did a great job back when this was initially adopted, which I think was in 1981, to talk about why agriculture matters. The economy, it's an agricultural land, it's an irreplaceable resource, it's to preserve the landscape and environmental resources, it's to help promote tourism, it's to help Vermonters be self-sufficient, and it's the general benefit of agriculture to help the welfare of the state. I think to even simplify it more, and I don't think people understand this enough, is farming is food. It's not just that farming is important. I think most people understand that farming is important, but most people also walk into the grocery store, buy their food, and don't really think a lot about where it comes from. Farming provides food, and food and water are the two most basic human needs. So Vermont, we've been fortunate enough that Vermont has always been an agricultural state, and we do produce a lot of our food. We don't produce a lot of our food also, which means we're getting a lot of our food, importing a lot of our food from other places, which just displaces the burden on other places, including the environmental burden, the cost of transport. So having the make food in Vermont is critically important. And that's why we believe it's so important to protect farmers. Now, to give just a very quick historical overview, I mean, the goddess of agriculture is on top of the building. It's pretty clear that at one point, farming was kind of all about Vermont. 100 years ago, about 80% of Vermont was covered in farmland. Now about 80% of it is forested. 100 years ago, there were tens of thousands of farms in Vermont. Now there's 6,500. But the composition of those farms has greatly changed. So in the 60s, after farming was rapidly devolving and had been devolving for about 50 years, people started to panic a little bit about the loss of farmland and the impacts of development. So Governor Hobb chaired a commission in 1968, which led to Act 250. And that commission was very worried about the loss of farming in Vermont. And at that time, about 43% of the land in Vermont was in farming. Now 9% of our land is harvested farmland. So when Act 250 was enacted in 1970, it's just a good barometer because we believe the reason it was enacted was to make sure that we still have farming in Vermont. We had about 420,000 people then. Now we have about 647. So our population has gone up since then by about 50%, but we've lost 56% of our harvested cropland. So while our population is expanding, our capacity and our ability to grow food is declining and declining rapidly. It's not just a historical issue, it's a current issue. So in the last ag census from 2017 to 2022, we lost 11% of our harvested cropland. That's 2% a year in just a 5-year period. And during that same time, just looking back at COVID and all the displacement backlog, in January of 2020, we had 649 dairy farms in Vermont. Now, the reason that's important is dairy is responsible for about 3/4 of the revenue that Vermont makes in agriculture. We had about 649 dairy farms 5 years ago. We have 441 now. We lost 22 dairy farms in November. In November 2024, we've lost 32% of our dairy farms in the last 5 years. Now that's a combination of a lot of different factors. Farming is really difficult. It's competitive. You're competing with your commodity. You don't set your pricing for a lot of the goods. So you're competing with other people who have a more favorable climate, longer growing season, less regulation. There's just the cost of land, the cost of equipment, the leveraging that farmers have to have. It's just all incredibly expensive. So there's all of these pressures on farms, which is why we keep losing. I mean, we're gaining in a lot of things. We're doing much better at environmental protection. We're doing much better at regulating a lot of activities, but farmers are getting squeezed, and we're trending toward New Hampshire, where there's very little farming left. And if you care about the ability to grow your food, if you care about the impacts of climate change and how that's going to impact our ability to grow food, ironically, Vermont's actually going to become a much better place to grow food than it is now. None of us want that. None of us want climate change. But it's true that very likely we're going to have a longer growing season and we're going to be less impacted by the severe weather, not unimpacted, but less impacted than other regions of the country. So our land base is sort of critical to all of that. And we're losing. And it's not only that we're losing the land base and farms, it's also that the new generation is not engaged in farming nearly as much because it is so difficult. The average age of farmers in Vermont right now is almost 58. That's pretty close to retirement age, and that's the average age. There are very few. There are success stories in Vermont, and Vermont farmers have been doing a wonderful job of transitioning to developing value-added products, of expanding their ability, but there's still these pressures that are leading us in only one way, and that's the steady decline of farming and farmland. So just to give you that, because I don't know that a lot of people spend a lot of time on that issue. But the issue we're here about is the law, and it's really kind of a small microcosm, and this is just about nuisance and trespass. These are common law claims that we inherited from people. Back when common law was applied in England, there was no regulation of farming. There was no town zoning. There was no Act 250. Like, this is common law claims, which are important. I mean, everybody has the right to the use of their property without interference from someone else. But the whole calculus of how we do things as a society has changed greatly from the time of the common law. And the problem that we have is the existing protection. If you look at the law, the purpose is great. We talked about that a little bit in the initial section. The definitions, we actually worked on those with Michael Grady in the legislature a few years ago. They're quite comprehensive now about the scope of what's included in the protection, which is great. But the protection itself is deeply flawed. And this is section 5753. And this is when Michael Grady did the analysis, the 50-state analysis, and determined that Vermont protection is weak. I think that's what he found. But to me, it's weakness is important. But what's far more important about this particular law is it's unclear. And when a law isn't clear, it doesn't serve the purpose. The purpose is to let people know what they can and can't do. This law doesn't do that. It sets up actually a circular construct that is destined to make litigation costly and time-consuming. And the reason that is this rebuttable presumption that's established creates a series of factual questions. And whenever you have factual questions, those can't be decided until you get to trial. So
just for clarity, both for the committee and folks listening, can you just describe what a rebuttable presumption is?
Well, it's honestly, from the statute, it's not particularly clear, but the way I think it's drafted, it basically creates an affirmative defense. So So if if a neighbor comes in and sues a farm and says, you're interfering with my use of property, that's a nuisance claim. In Vermont, you can state that very broadly and notice pleading and start your lawsuit. This then requires, if someone says your manure stinks, and so I can't enjoy I've got my lake home, I got my summer lake home, I'm traveling from California to Vermont summers, and your manure stinks. And the question then becomes, that can be enough. If it's so pervasive that it interferes with your enjoyment of the property, then the farmer has to, the way that I think this is set up with this rebuttable presumption, is the farmer then has to prove all these things. It's conducted in conformity with federal, state, local laws and regulations. This is the adverse of how normally when someone brings a claim, it's the plaintiff's burden to prove the elements that caused the legal violation. This flips that. So all the plaintiff has to do is say, you're interfering with my property. And then the farmer has the onus of proving that they're doing everything right. It's not easy to prove a negative. So if you're a farmer saying that your manure stinks, and the farmer is supposed to track down every possible law that can apply to manure, is supposed to explain what they do and explain how that complies with the law. That is a significant burden. And you can't just walk in and say it. You need to get an attorney to explain all the laws, very likely. You need to get experts to explain it. You need which provide opinions, and you need fact witnesses. But that's just the first one. That one is probably the easiest one to be able to prove. The next one is you have to prove the farmer. And again, the farmer has to prove this now, even though they're the ones that are defending the claim. They have to prove that what they're doing is consistent with good agricultural practices. That is incredibly vague. It's not defined in any way. So again, it creates a factual question that is only going to be decided by trial. And the problem with waiting until trial is that means you've got years of litigation in the interim where you're taking depositions, where you're conducting discovery, where you're doing all this work so that you can prepare for trial. So you're putting the onus on the farmer to do this. And if there's any disputed material fact, you have to wait for the court to decide that, which might be a judge or a jury. The next two are maybe even worse. I don't really understand how a farmer easily establishes that what they're doing was established prior to surrounding non-agricultural activities. First of all, what's surrounding? Is that your immediate neighbor? Is that a 2-mile radius where your manure smell may waft? Is that your community? Is that the new subdivision? I mean, and if you're talking about proving history, a lot of farms have been in place for 100 years. And you're supposed to go back and prove like when your activities started versus when someone else arrived. That's not protective of farming. That's creating a factual quagmire. The question shouldn't be what happened 50 years ago. The question should be, what are you doing right now? And is it reasonable? Are you farming appropriately now? Not were you here first. Were you here first actually discourages farming. And that's what this is set up to do. It's to allow people to remain. It's not allow people to farm and to change. And then the last one is the same issue where you have to prove that what you've done hasn't changed significantly, whatever that means, significantly changed. So if you go from chickens to goats, is that a significant change? If you have a farm stand, but you didn't before, is that a significant change? And the real kicker about this is we've been pushing farms, the state of Vermont has been pushing farms, the Agency of Agriculture has been pushing farms to diversify. When I said we had 4,000 dairy farms in 1970, now we have 441. Farmers are doing new activities. They have to, because they're not viable otherwise. So we're encouraging farmers to change their activities, become more efficient, to do things better. But then we're saying that in order to enjoy the benefit of the rebuttable presumption, they actually have to prove that they haven't changed. So, that's counterintuitive, and it actually works against what we're trying to do, which is to get people to improve their practices. So if someone used to spread manure, all winter long, which they were allowed to do, but now they do it like very effectively by injecting it in the soil so that it doesn't run off as much. That's great. But according to this law, that would be a significant change, and it would make you not entitled to the rebuttable presumption. That's bad law. It's not about weak. It is weak, but it's also not, if the law is poorly constructed. And then if the farmer does all that and they prove all that, then the plaintiff can still overcome that presumption by showing that there's a substantial adverse effect on health, or that there's obnoxious and significant interference. So that's not a good framework when you're putting the onus on the defendant to prove that their activity is appropriate. The general premise and how our legal framework works is if a plaintiff wants to bring a claim, they have to prove that you did something that violated the law. The prosecutor's trying to prove an assault. They prove that the person hurt someone else, and usually intentionally or at least recklessly, and that they caused injury. That's all that we are really asking for, is that if a plaintiff, a neighbor plaintiff wants to bring a claim, that they have to show the farmer did something wrong. And the farm, they have that burden of proof, and they have to show it, instead of just bringing your claim, putting all the onus on the farmer to show they're doing things right, and then still giving the plaintiff another bite of the apple. And so that's like what we think is most important, is to have a clear law, because everything about this law means that if once you're in court, you're going to be able to create a disputed material fact, you're going to be able to go through discovery, and you're going to be able to get to trial. And the reality of litigation when you're a civil defendant is once you're sued, you lose. It doesn't matter if you win in the end or not. It's the cost and the expense of litigation that is so detrimental. And that's what we're most worried about. Even if the farmer is completely right and hasn't done anything wrong, if they've got a wealthy neighbor or a neighbor who's committed enough to go to court, they can drive the farm out of business. Hiring an attorney is probably easily $250 an hour on average now. Just 40 hours of an attorney's time 1 week, which is nothing in a civil case, it's $10,000. That's more than a lot of our farmers make. And 1 week of time is nothing. If you're going to have to go to trial, you're talking about likely 2 or 3 years of litigation. You're talking about months of an attorney's time, and quickly you're talking about tens of thousands, even hundreds of thousands of dollars. That doesn't serve anyone's interest. The law should be clear so the farm knows, if I'm doing these things, I'm protected. If I'm not, then I'm not. And this setup that we have currently in the law doesn't do any of those things. So that's why we think this is important. And when you talk about these common law claims that exist, and that they preceded all the regulations, we now heavily regulate farms. That's part of the reason that farms aren't viable, is because they are so heavily regulated. We've imposed a lot of really important water quality requirements on them that cost millions and millions of dollars, which is great. It protects water quality, but it's expensive. It's hard for farms to do. And then if they're doing all those things right, the idea that a neighbor can still try to create their own claim, it's very disheartening and troubling for lawyers, and it doesn't create any certainty for farmers. So the real, in our opinion, the real policy question here is, who decides what a farm can do? Is it, individual neighbors and individual courts, or is it the legislature? And we think that the benefit of this, the law that Michael Grady has drafted and has proposed, is it creates standards. And it says what farms can do and what they can't do. And it says specifically that they have to follow all of the water quality requirements that are extensive in Title VI. They have to follow all of the pesticide regulations, which are extensive. So when they're using pesticides, that's controlled, and that makes perfect sense. And then there's also the caveat in the new bill that says they have to follow accepted language. Proper and accepted customs and standards. And that, in fairness, that's still vague. It still creates some issues. But the difference about the way this bill is drafted is it is defined. And it is defined to being in Vermont, and it is how commonly people do it. So that, to me, that's the balance of the provision. It still gives neighbors and other people who are impacted by farms an absolute ability to sue and to prove their claim. If a farm is,
what did you mention was vague again?
Well, I think so the way that the S45 is drafted, and I have a copy of that if anybody wants it, didn't have it in front of them. We have that. Okay. The way S45 is drafted is you enjoy the defense if you are, and this is on page 4, line 6, generally accepted agricultural practices. So that if you were fitting within that definition, then you are not causing a nuisance or trespass. The first two, A and B, are the ones I mentioned where you're following the law. The third one is practices conducted in a manner consistent with proper and accepted customs and standards, followed by similar operated agricultural activities.
Yeah, I think my understanding of port law, at least related to those topics, is if there is a comparison that can be made to another professional in that field who's in good standing, that's the comparison that's generally made. So I think that is what that comes from. I think it's drawing from what is commonly used with these tort claims. Torts are not my specialty, but I think that's the origin of it.
I agree with you that it's a reasonable standard, but I'm just saying that it creates some of those same factual questions I was just talking about that are in the existing law, because you can easily have two parties saying, no, this is not how you generally do it. And yes, it is how you generally do it. And so that leads usually to the battle of experts about what's customary and what's not. We're okay with that because it's at least defined. It's clear what else you have to prove that that it's to me, that's the catch-all. And the reason that I think the catch-all is reasonable is that not everything is regulated by the water quality regulations and the pesticides. So those regulations are extensive. And it feels like if the legislature says farms, you must do that, and farms are doing that, then that's a reasonable baseline. That if farms are doing everything that the law requires them to do, then the neighbors shouldn't be creating additional onus. But those regulations don't cover everything. So to me, that's the catch-all. Yeah.
Senator Volsky has a question.
I have a couple of questions. One is about the sort of reasonable and customary and how we addressed context. Something may be perfectly reasonable and customary on a big farm in farmland and may not be reasonable and customary happening in a downtown.
Yeah.
So I wonder how you view addressing the context differences.
That's a great question. And I think there's some built-in protections for that, because you can't have a dairy farm in downtown because you could never meet the required agricultural practices. You could never not have any runoff from your land. You don't have setback protections. You don't have, on a quarter acre lot, you just can't have livestock. You might be able to have a couple goats maybe, and manage it. But in general, there are some built-in protections. But that's a fascinating question. And one that a lot of people care sort of deeply about, because the ability to grow your own food is critical, and especially for people that don't have a lot of money, a garden or some chickens or some livestock can make the difference between their personal viability or not. So that's a great question. I think there are some protections there, and I don't think that the lot size would determine what's customary in practice. So if you have to keep your waste on your land. That's part of the required agricultural practices. But if you were following all those requirements and you're doing it appropriately, if you're managing your compost pile as you're supposed to, as an example, I don't think lot size is going to come into play there. There are some, really interesting interconnections between agricultural law, municipal law, Act 250, and the way but that's important. This only covers agricultural activities. It doesn't cover if you're doing other things on your land that are not agricultural activities. So I don't think that would change the customer standards, but you're right. It's an interesting question about, we have a way that we define a farm in Vermont of what you're subject to required agricultural practices. We've talked before about whether those standards should be jumped up a little bit so that it wasn't quite as easy to be a quote unquote a farm. We haven't come to a conclusion about what exactly that means, but it's an interesting area, because absolutely having a tenth of an acre and downtown St. Albans is different than having a farm out in Franklin. But the importance of being able to grow your own food and to be able to grow food for others is still very important.
Absolutely. No, and as someone who lives in a condo and grows some of my own food, I certainly can understand that. And have a very specific instance in mind that
I think I know what you're talking about.
You might. The other question I have, just in terms of is the sort of statement that the legislature should set the requirements. I agree, but sort of on the flip side of that is, how do we hold people accountable to that? And mind you, that is the judiciary.
Sure, and totally agree. And this doesn't change that. The proposal here does not change that in any way. Any neighbor can still sue a farm, no matter what you have the laws say. But what they can be successful at would change. And most importantly, from my perspective, two things. This would clarify, what a farmer is required to do, but it would also give the court the ability to quickly get rid of frivolous claims. So if the plaintiff doesn't meet the burden of showing, the farmer is violating the required agricultural practices by having their waste run off onto my field, if they can do that or even allege that, then they're going to have that's a factual claim that will be decided. But a lot of, if you can't even prove what the farmer is doing wrong at the beginning or after reasonable discovery, then the case should be dismissed. And that can be through a motion to dismiss or a motion for summary judgment. But the point is, you might do that within 3 to 6 months instead of 3 years. And that's why I think the clarity is so important, because most farmers can't afford to pay an attorney for 2 to 3 years, even if they're completely right. But if they're doing everything right, they shouldn't have to pay an attorney for 2 or 3 years. If they're not, then they should try to fix what they're doing wrong and settle with their neighbor as quickly as possible. And that's another beautiful thing, or a useful thing about this bill is the mediation. The mediation provision doesn't force anyone to do anything, but our society doesn't seem to be as open to talking to each other as we once were. So just oftentimes, if you get people in the same room where they're actually talking about their concerns, and if you're willing to listen, you can work something out. And there's actually a free ag mediation service that the United States Department of Agriculture supports. So there's a way where people could actually use that service. And that's what we hope for. When we get complaints all the time, and we're always encouraging both the farmer and the neighbor to work together, because the reality is we live in a society and we've got to be aware of each other's needs. But if the law is not clear, like right now, I've talked to people about what this law means. I'm a lawyer. I've been practicing a long time. I can't tell them what it means. I don't know. When did you start doing this? It's somebody who just bought a brand new farm. They bought a farm, or they bought a farm from someone else, and they're supposed to find out what happened 30 years ago or 60 years ago. And they're supposed to find out what neighboring house was built next, when they have to go to all the property records. And then to prove that is really troubling.
Steve, your testimony is really helpful. We do also have 4 folks on Zoom, and I think perhaps if you want to come back again, that would be great. But I also want to make sure that the folks have some time to testify as well. Of course. But Senator Noyes,
just one quick question, Steve. Me from an agricultural community, I can assure you that I'm somewhat aware of this. The hardships that they're facing today, everything from milk prices going down, feed and corn prices, seed going up. And we're losing a lot of farms throughout the state of Vermont, more importantly in the county that I come from. But having said this, with all the financial stresses that we're placing on farms today, do you have any idea as to how many of these nuisance suits actually have been put forth in the state of Vermont, and what the financial burden has been in the past for our farming community?
Well, there's no perfect way to do that without going court to court, because when there's an opinion written, you can find that through legal databases. But if there's that only happens when there's a decision made. So there could be many claims that are filed and settled. I don't think in general that it's really common for these claims to be filed, but there are claims that have been filed that are very significant in what they decide, including a recent one where a judge found that the smell of manure was a nuisance and enjoined it. The court found that the manure can't stink, or it can't stink on that neighbor's property. There was no evidence that I'm aware of that the farm was doing anything wrong with the manure. And here's this is a nice tie-in to the common law and what's currently required. So farmers used to be able to spread their manure all year round. There were no regulations about what they did with it. Now, to protect water quality, we require many farms to build 6 months of storage, meaning they've got to have the capacity to store their waste for 6 months. The reason we do that is so that it doesn't run off in the water. That's all great. But when you have to store manure for 6 months, it takes more. And you have to agitate it more. You have to agitate it so that it doesn't get all stuck together and so that you can't spread it. So we've actually imposed these requirements on farms that are really expensive for them, that don't benefit them in any way, except as a member of the community, that they're doing and they want to do. It protects water quality, but that also has collateral impacts. So when you are spraying, the manure is going to smell, it's more concentrated sometimes, and you have to, and when you're spread, it may smell worse than it used to. That's something we require them to do. And so now if you have a farm that's doing everything right with its manure management, but a neighbor has a summer home on the lake and doesn't like the smell, and that neighbor sues for nuisance, and the court actually agrees that smell is impacting the neighbor's ability to enjoy their property, I don't know how the farm handles that. And that happened. So I don't think they're super prevalent, but I think the risk is what's really problematic. I mean, farmers have so many things poking at them all the time: labor, costs, mortgage payments. If a neighbor comes calling and says, you've got to stop doing that, and they don't have some protection in law, that can be debilitating. And when there's so many things that are already driving farmers out of business, all we're saying is when it comes to nuisance and trespass, let's create some standards so that they have some ability to defend themselves if they need to. And keep in mind, this is just nuisance and trespass. If a farmer injures someone, this has nothing to do with anything. This is very limited common law property claims. So if we're going to require them to do all these other things, maybe let's also make it clear that if they are doing all those other things, that shouldn't sustain an independent nuisance or trespass claim.
Thank you.
Thank you.
Yes, no, thank you so much for your testimony. And I would be more than happy to come back if you have any questions. Thanks.
So I see we have Bradley St. Pierre. I'm just gonna start from the top of the list. Mr. St. Pierre, are you with us?
Yeah, I think so. Can you hear me okay?
We can hear you.
Hey, how's everyone doing today? So, I'll just introduce myself a little bit. My name is Bradley St. Pierre. I'm 27. I'm a fourth generation farmer. I'm on my family's farm here in Berkshire with my brother and my parents. My brother is 29, and we are both been in the process of purchasing the farm, transitioning the farm for about 7 years now, since we both came home from college. Like many other Vermonters and dairy farmers, we have long historical ties dating all the way back to the Civil War to Franklin, Vermont, and some of my ancestors have been in Vermont since 1791 when it was founded. So I really love Vermont. I'm happy to raise my children here. I got actually my fourth kid on the way. Me and my wife are expecting another son in June. Feel really lucky. I'm excited to raise my family in Vermont and hopefully keep farming here. When I came back to the farm, I didn't expect to be Zooming with Senate committees, and I Zoomed with the Ag Senate Committee a couple weeks ago. And so I'll apologize. I'm not the most well-versed and best public speaker, but I'm just here today trying to represent my family and my farm and other neighbors in our community on this right to farm bill. That's very important for my future and my neighbor's future, you know. I think it's important to talk about that this farm, obviously dairy, I'm a dairy farmer and we also make syrup, and obviously dairy is a really big part of agriculture in Vermont, but this is not going to exclude the Christmas tree farmer or the goat farmer or the vineyard. This is for all farmers. It's not exclusive. I think it's also important to talk about, he said, talked about competitiveness. So I went to college in New York for diesel mechanics, and I have a lot of friends that dairy farm across the nation, and it is competitive with them. And sometimes you say, oh, we have a dairy farm in Vermont, and they chuckle because when they think of Vermont, they think of trees, and we make it work, and we farm hard just like our neighbors do. And with the regulations and the rule, not only is the land tough to be competitive with, but it also is making it hard to be competitive efficiency wise and stuff. And he explained some of that prior to me getting on here. I wrote down some notes here to kind of be a little bit clearer in my opinions. So we talked about the demand for more housing, compete with goals, keeping land in agriculture. So it's always a challenge, right? Because of housing developments, we need to keep land and farming. But on the other hand, to clear land or to create new land is really hard. It's really regulated in the state of Vermont. So it's kind of on one hand, we're competing against developers, and on the other hand, we can't really make new ag land. So we're kind of stuck between a rock and a hard place on that point. a lot of dairy farms like ourselves choose to diversify. Like I said, we sell maple syrup. That's been happening for a long time throughout Vermont. We're really well known as maple producers, as all Vermonters. This bill is important because it protects the investments that we are making in land conservation, water quality, efficiency grants, education. Every summer, something cool that we do, I'm proud of, is we do a dairy camp. And so we bring a calf to a whole bunch of local summer programs at local schools. And sometimes we bring a tractor and let the kids see it. And we just try to educate young kids on farming just because there's less farming. And I think that a lot of these issues are created because people are growing up farther away from the farm, which isn't their fault, but it just out of naiveness, they don't really understand the lifestyle or what we're trying to accomplish. And so we feel it's our responsibility, like me speaking here today, to educate and tell our story and communicate what our goals are and what our future is looking like. One thing that we should look at, and I think it's really important, is we should move the requirement for what's considered previous ag. So it was 10 years dormant, and then you guys moved it to 5, or it got moved to 5, I should say. We all feel that we should move it back to 10, meaning that if a field hasn't been cropped in 10 years, it's still considered ag if you start cropping it then. Another thing that we should address in this bill is formal mediation before court, giving the two parties time to communicate, have civil discussion before, going into the full on court proceedings, depending on if there is an issue or how big the issue is. My biggest fear going forward, and as I hope my children come back to the farm, is regulation in Vermont and, doing the right thing. I think, we're down to, you got 441 farms. I think, most people that are left farming want to do the right job. And I think that, we're getting over-regulated and we can't even just do our normal chores. And I really fear for my children. Obviously, I fear about low milk prices or rising costs to employ help and all those things that go with being a business owner or a farmer. But I think the over-regulation is going to be the first one to take out some more farms. And so I think that we need to both the state house and farmers communicate more and make sensible regulations to both protect, Vermont non-farming Vermonters and waterways and our farmers. I think that there's a happy medium in there. And I think that we can all get what we want. We can all, the out-of-stater with a second home, can enjoy the lake and enjoy their time in our beautiful state. And I think that we should be able to continue farming like my ancestors did, and hopefully my kids do. I didn't have a ton. Those are just some notes I wrote down. I don't know if anybody has any questions, or we can just move on to whoever's next. Again, thank you for having me.
Thank you, Mr. St. Pierre. Appreciate that. Committee, any questions for Mr. St. Pierre? Okay, thank you. Appreciate it.
Yep, thank you.
Next up on the list, we have Mr. Poulin.
Good morning.
Morning.
I will introduce myself. So I'm Josh Poulin. So my family has been farming, and I also own Poulin Grain Feed Company here that supplies. We do bag feeds that are throughout New England, and we also provide nutrition for Maine, Vermont, New Hampshire, Connecticut, Massachusetts, New York. So we've got I've got a pretty good outlook, at least at farming, kind of across the Northeast here. So anyway, my great grandfather moved here from Canada and was a dairy farmer and started the feed business at that time. So Bradley did a good job there of explaining some of the things at the farm. I should tell you this. So I do still milk 250 jerseys up here in Newport or Derby, Vermont, and have three grain facilities in Vermont and employ it's about 90 people in Vermont at the feed company and about 10 people at the farm. And then got a few more people outside of here, obviously, that are through the Northeast. But I do think there's a few things. I think this nuisance thing not a big deal till it's a big deal, to kind of answer the question that got asked earlier. Farming, the thing that people tend to forget, and Bradley brought this up, they're not as close to the farm as they used to be. People that don't farm, right? I think back in my great grandfather's day, I think everybody had something because they had to, right? That's the way people survived. And today that's not maybe the case, and people don't always understand what we do isn't real sexy sometimes, right? Manure stinks. Cows can be dirty. It's not always glory. If you love it, you love it. It's kind of like anything, right? It's almost an addiction. I think farming. It's a great thing, but it also, I can understand when people aren't used to that and being next to that it can be it might be a nuisance at times, right? If it's 90 degrees out and you've took, we crop when it's nice, we spread manure when it's nice. When it's not nice, it's hard to do that. And I do agree with Bradley that the regulations have gotten a little overwhelming here in Vermont when I look at other states. Like I said, we do business in other states too. And farming has changed, and farming is had to get bigger to honestly compete. And one of the things that Vermont struggles with, I think, is that ability to be able to do that, right? We do have, our landscape is beautiful. We have hills and mountains and all that other stuff, but that also comes with some of the regulations that we have with runoff and some of these other requirements that have been set on us as farmers. And that's okay. I think we can live with that, but you can't be tied up in court for 3 or 4 years for a nuisance claim on because your neighbor's a little bit unhappy about how your manure stinks. At least that's my opinion. I think that gets challenging. I also think that I've had to deal with Act 250 some in my business, and that the regulations both on the farm and on the farm support, actually the infrastructure we have back to agriculture, whether it's the grain company, whether it's the tractor dealer, whether it's the co-op. I mean, I think, not to get off on a tangent here, but I think the state really needs to look at that, because we are competing with those other states for agriculture and producing food. And this is a great place to do that. But we like every state, everybody has their strengths and weaknesses. And we just got to make sure that we're not creating some of our own weaknesses through law. And the fact that that's going to hinder our ability to be able to operate here. Because if it costs $2 more a hundredweight, just for an example, or it costs or $10 more to raise a chicken, we're not doing that in Vermont. We'll do it. We're going to have to do it somewhere else, right? I mean, that's just how that goes. The market is way too competitive on the other side for food, and we're seeing that now. I mean, you look at eggs, $6, $7 a dozen. You look at beef, what that's going to do probably. You look at dairy. And grain costs actually have come down some during this over in the last year or so. But all the other costs have been, whether it's fuel or whether it's fertilizer or some of these other costs to the dairy have just been, and other businesses, maple, whatever. There's nothing excluded, right? And when you're not able to just set your price on for the product, I mean, you definitely have to figure out how to be efficient and do whatever you can do and to save money. So back to this bill, I think it's important for something to be set in place to make sure that we can't get sued for things that don't make any sense. And I get the question about, we deal with those little backyard or like little tight in village farms, right? We sell feed in bags, and I get some of that, and I can understand that, but there's a different level, right? There should be some distinguishing between a guy with 2 goats or a beef in his yard and someone like Mr. St. Pierre or some of the other, Mr. Manning or myself or whoever else that are milking or have a whole lot of animals, right? There's 2 different levels. It's hard to regulate those, in my opinion, exactly the same way. When I think of a farm, I'm thinking, a farm, right? But I do understand that people have to have the ability to grow, and I want them to, because they buy feed from us, and it's a great market to be able to raise things on their own property, right? But there's different levels of what that is, and there's obviously different regulations for that. So I appreciate the time. I don't have a lot. I think that I think the state, I'll just say in closing, I think the state really has to think about agriculture in the state and what's important, and try to come up with some things that are a little bit more in line for both parties. We're actually making food for everybody, right? I mean, the old saying, I always figure, air, water, food, right? Shelter maybe number 4. It's a really important thing for us to be able to do that. And I think that I hope that everybody can find a happy medium and support some of this stuff as we go along. So thank you for the time again. And if anyone has any questions, I'm happy to answer.
Thank you, Mr. Poole. Committee, any questions? That doesn't look like it, but yeah, thank you for your testimony. Appreciate it. Next up, we have Mr. Corse from my favorite county in Vermont, Wyndham County. Mr. Corse, are you with us?
I am. I'm not going to turn on my camera because our network, internet is very poor, and it may be what it takes to terminate it for me. We farm in Whitingham on a farm that's been in my family for 157 years. I'm 70 years old, and I'm the 5th generation here. I'm in the process of transferring the farm to a daughter in her 40s and a young man in his 20s who is not part of the family because my daughter doesn't want the whole responsibility of the farm. You may have heard of her, Abby Corse. She served on the Vermont Climate Council. My wife, Linda, is heavily involved in the conservation districts of Vermont, including being the board chair of the state organization. I serve several capacities in Organic Valley, the cooperative. I'm on the board of directors of the Dairy Grazing Alliance. I served on the Governor's Commission on the Future of Agriculture, and Anson Tebbets recently appointed me to the organic seat on the Ag Innovation Board. We milk 55 cows here. We are a grazing farm. We always have been. And we've never had a lawsuit, but we've had some experiences that could have led to them. We have 26 landlords to run this farm. Most of them are out-of-staters who have second homes here because the main industry in this area is tourism. We have trouble with deer and moose going through our fences, and then the animals get out. It's impossible to check every fence every day because we have miles of electric fence. And so occasionally the animals get in the neighbor's garden or on their lawn. And we had a very difficult situation a few years ago with a New York City stockbroker who has a perfect lawn, and the cows got on it. And I thought we might be going to court, but we ended up not having that happen. We commute our cows down the town road to get to pasture in the later part of the summer from August through October. It's 3/4 of a mile on a gravel road. We've been doing it for about 65 years. The time of day is predictable, and so people can avoid coming on this road. There's other ways to get around, but there are 4 houses between here and where the cows, and right now those landowners are all comfortable with this happening. But envision a scenario where someone buys one of those houses and they have a white Cadillac or Mercedes. They leave some manure in the road, and that doesn't look very good on those white cars. So we've had some run-ins with people. I tell people when we commute the cows, there are 2 types of passers-by. There are those that get out and take pictures and think it's the greatest thing they ever saw. And there are those that can't swear fast enough. And there's no middle ground. People into one category or the other. So I see some potential there for lawsuits if the wrong person buys some of the neighboring properties. We also spread liquid manure. As Steve mentioned, we have to have storage. In our case, we have to have 7 months of storage because, as my great grandfather, who lived his whole life here, used to say, when you live here, you expect 3 months of winter, 6 months, 9 months of winter and 3 months of difficult sledding. My understanding is this bill only protects us against lawsuits. It doesn't exempt us from any rules or regulations, so it's pretty specific. So I think that it would be a great thing to add to the right to farm capabilities in this state. And I would be happy to answer any questions if you have any. Thank you.
Thank you, Mr. Corse. Appreciate it. Committee, any questions for Mr. Corse? Doesn't look like we have anything in the room, but thank you for your testimony. Next up, we have Mr. Manning, I believe, from your district. Mr. Manning, are you with us? Mr. Manning? Not sure. I noticed that you unmuted, but we're not hearing anything on our end. Mr. Manning, if you want to try maybe rejoining, or if there's anything with your microphone that you might be able to fix. Does anybody have his cell phone maybe send him a text or anything?
I just texted him.
There we go.
I think that's Brad.
Yeah, this is Bradley. I just texted him.
Thank you. We'll just give Manning a second here.
Can you hear me?
Yep, now we can hear you.
Hey, sorry, my computer audio is not working, so I did the call in.
Not a problem, but you're loud and clear now.
Okay, thank you. My name's Oliver Manning. I farm in Swanton, Vermont, alongside my father and my brother and my nephew. I'm the 5th generation to farm here. I agree with everything I've heard this morning, and I actually think I can offer a unique perspective because I serve on the planning commission for the town of Swanton. And we are currently rewriting our zoning laws. And one thing that's come up a lot is agriculture and agricultural land. There's currently a small berry farm in Swanton that is dealing with this very issue. They have been sued by a neighbor. They've been in court for over 2 years, spent over $40,000 of their money. And in all my conversations, the only thing that they're being challenged on is that they're not actually a farm. They have all the correct paperwork through the Agency of Agriculture. They've been permitted by the town for their stand and the business. Yet this neighbor is unhappy with them for some reason and has tied them up in court. So I see this legislation is very important, not only for us as dairy farmers, but to help our total communities, no matter the size of the farm. The other thing I see a lot is a lot of urban sprawl coming out of St. Albans. We're right on the St. Albans town line, next to the interstate. And it seems every year there's half a dozen or a dozen houses that are creeping closer and closer to the farmland. And as Mr. Poulin said, this isn't an issue for everyone until it's an issue, and at that time it's too late. And it's really just another hit against farmers to try and afford litigation to do just to stay in business when they have done no wrong in the state's eyes or the town's eyes. It's just someone that isn't happy with you. And this is something that for larger farms can definitely be an issue because they cover more area, more neighbors. But as Mr. Korse said, this is something that also affects the small farms in something as simple as manure on the road or a cow getting loose onto someone's lawn. And also, as he stated, that we're not changing any laws in the effect of what is and isn't allowed. We're just looking for some protection for the farmers. And that's all I have today. If you have any questions, I can answer them.
Thank you. Committee, any questions? Senator Holmes?
I did, and maybe I misunderstood, but my understanding was that agricultural land was exempt from zoning laws.
That is a topic of what counts as agriculture that we've discussed, but it is exempt. But the problem that we're facing is there's a couple of one in particular, a small beef farmer with maybe 40 head of beef that has he owns a small parcel of land, but he's always hayed a half a dozen or a dozen small 3 to 4 acre meadows. And now those have been bought up by developers. And now there's 2 or 3 condos going up there. And this guy is now looking for feed for his cows because he's losing his agriculture land. And then now people are angry about the situation of his cows, where maybe they used to have 100 acres of grazing land, and now they're being shrunk into a smaller area, so it looks more like a feedlot than a nice green pasture. So it's just, there's a lot of pressure in our area in northwestern Vermont, as we're probably one of the few counties that's actually growing in population, that what are farms going to do with the new influx of people coming from everywhere to protect ourselves. And I actually learned something from the first speaker, that this law would not, so our family recently purchased a dragline manure system to inject all of our manure. And if someone has a problem with that now, we're open to litigation because it's a new practice, even though it's the same thing that we've been doing, but it's not, it's a different way, in which I think is a better way. But it leaves us liable, not liable, but open to that complaint or court.
Okay. Thank you.
Thank you.
Thanks for having me.
Mr. Korse, I see you raised your hand. Did you have some additional testimony?
Yes, I was just going to comment on that last question. We're in the process of conserving a 10-acre field that is within the village of Whitingham. And it's literally the flattest piece of property of the 350 acres we farm. And yet, because it was within village, designated for housing, there was a provision in the town allowed to be used for housing at a greater density than most of the town of Whitingham. So we had to jump through some hoops to be able to conserve it because of how it was in the town plan. So this is an example of the kind of things that we should be exempt from, but we're not. Thank you.
Thank you. Right. Committee. So we are, thank you to all the folks who were in Zoom and able to testify. Appreciate it. Committee, we're going to move on to S12. We have Marshall here and do that for about 15 to 20 minutes. So we'll have a few minutes before we have our joint assembly. Let's carry on.
Carry on. Right.
Morning.
Morning.
Glad to be here. Marshall Paul, the Office of the General, Deputy Defender General, and Chief Bureau Lieutenant. So we've had the time to review the new draft of S12. And to sort of cut to the meat of it, we oppose the bill. We have a system of expungement that works. In fact, the system of expungement that we have works better every day, as we have, at the beginning, when we were dealing with expungement bills 10 years ago. The big objection, the big concern was the bureaucratic nightmare of actually destroying all the paper files. Now that files are all computerized, it is getting easier and easier to do effective expungement. And so really what we have is a system that has been working and is now working better than it ever has been. And this bill would propose to essentially scrap that for a system of sealing, which really requires immense record retention. From our perspective, that doesn't provide any benefits. There's no benefit to having something sealed rather than expunged, and there's a lot of detriment to it. To begin with, just the very obvious thing is the amount of access that people have to those files. The access that is contemplated in this bill is sweeping. The number of people right now, if somebody gets a record expunged, essentially 0 people have access to that information. Researchers can look at it under the terms of a non-disclosure agreement. And there's a special index that's kept that allows the person who's the subject of the expungement to look up the expungement if they need to it comes up for like when we have clients who need to get a federal security clearance and they need to be able to show what the results, what the disposition of an arrest was, things like that, immigration status adjustments that comes up for that as well. And I would add to that something else that's developed in the last 10 years that also really sort of militates against a sealing bill rather than an expungement bill is the incredible increase in data breaches of secure systems all over the country. And in particular, what hackers target is they target systems that contain sensitive information. They are attacking banks, they're attacking health networks, hospitals, medical providers, insurance companies, and they are attacking the governments. All they are trying to do is get their hands on sensitive information, which they then ransom. So they did this to UDM, they steal a bunch of patient data, and then they turn to the company and they say, if you don't give us, whatever X number of millions of dollars, we're going to release that to the public. That's been happening to state judiciaries. You can go online right now and you can download almost the entire docket file for several years of the Kansas State Judiciary. And it's because Kansas they did not have the ability under law to pay a ransom to the hackers that stole that information. I went online to see if I could find it. I didn't click on it because I wasn't sure of the legality of downloading it because I know it to be, the data that was stolen, but it is that easy to get. And as long as we have a system where we are storing all of these records in perpetuity, it's almost a guarantee that at some point those records are going to become public because somebody's going to hack our system, get the access to the documents. The state of Vermont is not going to pay ransoms to hackers in Russia or China, which is what private companies do. These hacker groups actually have a good reputation. Or if you do pay the ransom, they give your data back and don't release it. And that's how they get the credibility to get people to give them money in the first place. But that's generally something governments can't do because they're not authorized to do it. And so this, the county that has Lincoln, Nebraska, they lost all of their data to hackers. That's publicly accessible too. So really one of the things that expungement does that sealing does not do is it protects this data from being hacked and released to the public. Keeping data online for long periods of time is just a way to guarantee that it eventually winds up out there in the world. Additionally, we're really opposed to the elimination of expungement because it's one of the best tools we have to help people desist from committing crimes. There's been study after study that has shown that expungement leads to desistance from criminal activity. People who get an expungement are less likely to commit crimes in the future than people who have a criminal record. There's studies that show that getting an expungement leads to massive increases in income in a really short period of time. And frankly, getting an expungement simply makes people feel better. It makes people feel like I have a lot of people who call our office asking for advice about expungement. And my first question is always, what do you need an expungement for? Because that changes what my advice might be about how to pursue an expungement, what way to pursue an expungement. If they need an expungement for employment reasons, that's one thing. If they need it for educational reasons, that's another. If they need it for application for military service, that's another. There's all kinds of things. And honestly, one of the things that comes up most often is people who just say, I don't need it. I just want it. I want it to clear my record. I'm not the person that I was 20 years ago, and I don't want this on my record. I don't want people looking at me and seeing that as a reflection of who I am today, because it's not who I am. So there's all kinds of reasons that people want expungements, and some of it comes right down to people who want their record to reflect who they are. So for all those reasons, we don't see a need to change the current system, and we do not want to see the elimination of expungement. That said, if we were to go forward with a bill like this, we would not support this version of a bill like this. This bill certainly, from our perspective, decreases the number of offenses that are eligible for sealing rather than expungement, and makes them more available to a larger number of people and less protected from data breaches. And what I would compare this to is last year there was a bill that was proposed, actually, you were one of the co-sponsors, Senator Norris, S-299, which was a similar bill in that it also essentially eliminated expungement in favor of sealing. But it did much more than this bill did. Instead of shrinking the number of eligible offenses, it vastly expanded the number of eligible offenses. So rather than saying, here's a list of the qualifying crimes, it said, here's a list of the crimes that don't qualify. So it's, almost a flip-flop in terms of the number of offenses that are available for sealing under their version. Also under that bill, there's a provision for automatic sealing. So people wouldn't need to file a petition for certain categories of crimes. Certain categories of crimes, after a certain amount of time had passed since the completion of the sentence, then the sealing would be automatic. No petition needed. It would just happen. From our perspective, again, we oppose anything that eliminates expungement because we think expungement is one of the best programs in the state today for, in terms of the way that it handles criminal records. And we think it's going to be more important in the future. But to the extent that we were going to be eliminating expungement, we would say the starting point should be last year's S-299, because it provided a lot more protection and a real expansion of the scope of sealing. I want to talk about one more thing before I wrap up, which is the incredible complication that this bill would entail, because this bill sort of purports to eliminate sealing, but it doesn't, or eliminate expungement, but it doesn't. We would instead have to have parallel systems of sealing and expungement for quite a long time. And that's for a few reasons. One is that, obviously this doesn't eliminate expungements for deferreds. We think that's a good thing. That's been in practice in Vermont for longer than I've been alive. And has always been sort of something that Vermonters, it's essentially rely on and expect is our deferred sentencing scheme and what comes along with it. And that's a tradition that we don't feel is appropriate to change. It's not changed here, but that does mean that already you have to have a system for expunging files and a system for sealing files. What I don't think anybody's addressed that's actually even more significant in terms of the need for having parallel tracks is retroactivity. So Title I, Section 214 addresses the retroactivity of statutes. Whenever the legislature passes a statute, there's always has to be an analysis done as to whether it applies retroactively or not. And in this case, it's pretty clear that it would not apply retroactively. It would only apply prospectively, because anyone who's already accrued the rights to an expungement is entitled to that expungement. That can't be taken away from them by statute. And so there's thousands and thousands of Vermonters who have accrued the right to an expungement. They are eligible for an expungement. They never filed for an expungement. We can't now say, by operation of law, you're now no longer eligible for expungement, because that's a liberty interest that they already have. And so that can't be taken away retroactively. So we would, for a long, long time, because right now the way expungement works is you have to file a petition, and there's plenty of thousands of people who are eligible who have to file petitions. And until all of those people are no longer living, we would have to have a system for expungements so that everyone who's already accrued a right to an expungement can get their record expunged, as well as this new system for sealing for all of the new cases. So from our perspective, in addition to just not really being a benefit, not solving any problems that need to be solved, we look at this as really adding a profound layer of complication to our system of sealing and expungement.
So a few quick questions, and I think hopefully we can have you back next week, because I think there needs to be more conversation about it. And we only have a couple of minutes here. Regarding decreasing the number of offenses eligible for sealing, my understanding is we're adding a whole lot of offenses that would be eligible for sealing. What am I missing?
I'll tell you what is all, if I'm coming back, I will make a chart.
Okay. I'm seeing that we're adding about 26 felonies, give or take a few. I can't remember the exact number. But we are, well, you said you'll bring a chart.
I'll bring a chart. The way I read it, and maybe this was too fast of a reading, I read quite an expansion in the misdemeanors and another expansion in felonies. And I guess by my count, it was a little bit tilted towards the expansion of accepted misdemeanors that aren't available for sealing, and an increase in felonies that are available for sealing. And I had sort of added those up and came out of balance one way, but if I put them on the chart, maybe it'll tilt the other way.
And the other thing, you had mentioned the increase in income. I was looking at the Michigan study. Is that where you were getting that, the 22% increase in income after expungement?
That's actually sort of an outlier. There's been multiple studies looking at income after expungement. Michigan is the only one that's come up with a number as high as 22%. Most states have been more like 10 to 15%. And that's, but it's still really, I mean, that's significant. I don't want to diminish the significance of that. I mean, I love a 10% raise. It's 10% is a significant bump.
And I think I don't want to dominate with all these questions. I think we should have you back next week, and we can.
As far as next week goes, I'm not available Monday, Tuesday, Wednesday, because I have to go to the plant also.
Yeah, okay, well,
But, Thursday, Friday, I'm available.
okay, sounds good. We'll, follow up with Kayla and try to get some more testimony in. I want to give the committee some time to get to, take it real quick before the floor. So
Absolutely.
thanks for coming in. Sorry it was brief.
No problem.